that that's what you'll follow. But you raised your hand and swore an oath to seek the truth. Not follow their red herrings and not follow their smoke and mirrors. So let's talk about the car, since I'm on the car. They want to talk about the car. That Mr. Olmsted and Mr. Harper. Y'all remember Mr. Olmsted and Mr. Harper? They testified right in a row. I cross-examined both of them. Mr. Harper said on direct that although she said it was midnight, and one of them did in their closing that it was midnight, you'll remember the testimony. That's not what he testified to. He said he got up early that morning. I remember that because I cross-examined him. I said, sir, in your statement to the GBI, you said you didn't get up until about noon. No, sir, I remember I got up that morning and I walked to the Swanee Swifty. Get something that morning. He didn't say midnight. Not what he said. But you trust your notes, you trust your memory, not what Miss Merchant says and not what I say. You trust what you remember. But that's what I asked him on the witness stand. And he said, no, sir, that was that morning. And he said, after that, I don't know. And then they put up his roommate after him to say that he didn't see the car. He said it was that afternoon. Not that morning, that afternoon he said about 3 or 4. Because you know why? He said, I slept till noon. He said that he admitted he slept till noon that day. So he didn't know what happened that morning. He didn't even remember his roommate getting up. Although his roommate's statement said it was about noon and testified here it was that morning. He just doesn't remember. Both of those good people, not trying to lie, just trying to be helpful. That's all. They're just wrong. Living there across the street, whatever day. It may have been that her car was gone or not. They're just wrong. And then remember when I asked his roommate, and you and your roommate went to Wendy's to get something to eat about 4 that afternoon. Yes, sir. And that's when you saw the car not there. Yes, sir. And his roommate didn't even say that. He said it was early that morning when he went to the Swanee Swifty. He said nothing about Wendy's. They're just it's a long time ago. They're just mistaken. That's all it is. They're just mistaken. All of those other witnesses said the car was there when they drove by. Heath Dykes tells you it was cold to the touch when he was there. The car never left. The car's not an issue. In fact, in Ryan Duke's own statement to you, his videotape confession, car's not an issue. They want to make the car an issue to make you look somewhere else away from the truth, away from his statement, away from the glove, his DNA, and his fingerprints. Because the car, we got to get the car out of there. We got to get her away from the house because she wasn't killed at the house. But that's because they need to get away from what their client says. They don't want to talk about that statement. Notice they didn't play the statement for you. They want to say hiding stuff from you. Why didn't they play something of it? Because they know the statement makes him guilty. That's why. So let's talk about the palm prints. It's his palm prints in the glove. So his DNA is in the glove at a 90 to 10%, a 50% on the outside, and also his palm prints in a glove. Now let's talk about this for a second. They want to say it's a plant. They get up here and they attack Miss Hinkle, who testifies that she found his DNA, and they want to say that, they didn't follow procedures and didn't do this and did that. And then they want to attack Miss Worley about her identification that she really didn't identify. Innocent people only need one defense. If Bo planted it, so what if it's his DNA? So what? But they want to fight that too. Why? Because it makes their client guilty of all of it. With every question that they ask, with every witness that they call, you remember their client confessed. Who's hiding things from you? Who's trying to misdirect you and make you go a different direction? That table. With that defendant in that chair. Let's talk about her home. Miss Grinstead, they want to say there's no crime scene at the home and investigators couldn't say, you know what, it's a fair statement. The investigators couldn't say one way or the other whether it's a crime scene or a sign of a struggle or not. Fair enough. I think that's a fair assessment of the evidence. But one interpretation of the evidence is that in fact there was a struggle there and that something happened in that bedroom or in that house, and that defendant told you it did. So there is physical evidence that supports that it happened in that house. What did Maria Hewlett tell you? Maria, I forgot her last name now. The alarm clock down on the floor blinking 12. What else did she tell you? Well, the other young lady that was there for the beauty pageants, I forget her name at the moment, but pretty young lady that came in and talked to you about being over there for those drawers were pulled out. That's not the way out. She said she came back after they left. There were extra drawers pulled out in those dressers. Top drawer, bottom drawer. Where are you going to trip over when you leave that one out? And I agree with Mr. Merchant. Ladies aren't going to leave those throw pillows on there. They're going to take those off. We're not saying she was asleep in the bed. What does he say? He says she came up behind him and surprised him. But that can be evidence of a struggle. Doesn't have to be, but it can be. So there is evidence in the home that there was a struggle. Oh. Remember where that glove was found in the border of the landscaping? What's in her bedroom floor? You want to tell me Tara Grinstead is going to leave pine straw laying around on her floor? Lampshade is askew. May or may not be anything, but it may be something. I mean, I turn mine. You probably turn yours to get some better lighting. But it may be. So even though we can't say that there definitely was, there is evidence that there could have been. In fact, drawers pulled out. And that chest is off center down there at the bottom of the bed. Right away where you trip over it. Tara, or the young lady that testified that Tara was helping them with the beauty pageant, said they didn't even get dressed in her bedroom. They got dressed in the kitchen area. Another shot, drawers pulled out. And a candle on its side. A candle on its side. So again, investigators want to be truthful with you. We can't say one with that, but there is evidence that something could have happened in that bedroom. And there's blood on the comforter. Let's talk about this phone call. The defense has to come up with a theory that explains that phone call because the GBI agents, Rothwell, Shadell, they all told you what? That's guilty knowledge. They hid that from everybody. So they've got to explain that phone call. So the way they come up with explaining it is he's a good Samaritan. You saw them attack the phone records when we were putting the phone. They didn't want those phone records in from North Coast Pay, the payphone. They objected to those documents going into evidence. Who's trying to hide something from you? And then their client gets up on the stand and admits it, that he made it. Who's hiding stuff from you? Well, where's the smoke and mirrors? Sorry, Ms. Hart. Go ahead.
So you said you went to, what kind of phone did you use?
This is a pay phone.
You remember which store it was?
The G&G now.
The one right next to FedEx?
Yes, sir.
So you went to the pay phone there, you said?
Yes, sir.
And how did you call the house? What did you do?
I dialed 411 to get the number because I couldn't answer. And drove by.
you were hoping that she would answer the phone, and
Yes,
when
sir.
she did, you knew something was wrong.
Yes, sir.
What did you do to clean up? You said you wore.
The phone records. Why do you believe his statement, his videotape confession? Because the physical evidence corroborates it. Physical evidence doesn't lie to you. People will lie to you, no doubt. But physical evidence that corroborates it, just like you've got evidence corroborating a struggle in the room, doesn't have to be, but it does. Phone records corroborate that phone call. On her caller ID in the North Coast pay records. And he's the one in that statement that volunteers, I made a call. He asked him about phone calls. He does. Agent Shadell does. But then, you know what he says? I made a call from a payphone. Not from Agent Shadell. At the Swanee Swifty. Just right here by our house. Now, ladies and gentlemen, let's talk about that just for a second. You're living in Fitzgerald by the hospital in a trailer. You're not going to dial from your home phone to check on Miss Grinstead? What about a payphone in Fitzgerald? You're going to drive 10 miles to Osceola to make a call from a payphone? Just to return her purse. You don't go to the police and say, Miss Grinstead's purse, I found it, needs to get it returned to her. You don't go to the police in Fitzgerald and say that. You don't go to the sheriff's office in Ben Hill County and say, I've got Miss Grinstead's purse, just wanted to get it returned to her. Didn't know if something happened to her, y'all go check on it. Don't go to the Osceola Police Department when you get down here. You don't go to the Irvine County Sheriff's Office. You go to a payphone. Don't call from your home phone. You drive back down to the scene of the crime. And ladies and gentlemen, he tells you in his statement that he calls her to, he told you on the witness stand he called her to check on her. He tells you in his statement he called because, remember what he said? No cops were around. Yeah, it's church time in Osceola. People are going back and forth to church. He's calling to make, to disguise who he's calling. Because 411 comes up a payphone. Because if he called from his home phone, it's his number that comes up. Or his relative. And he's calling to make sure nobody's found her body yet. That there aren't police already there. He doesn't leave a message. Miss Grinstead, I have your purse. Found it. Wanted to check on you, make sure you're okay. Hangs up. And ladies and gentlemen, to get that glove right, for Bo to plant it, in their theory of the case, it doesn't even make sense. Because Bo would have had to have planted it after Heath Dykes was there midnight Sunday morning and before Joe Portier sees it, before they all go over there. And get Tara's DNA and Ryan's DNA, and Ryan's with Bo every time after that. It doesn't even compute. It's impossible. But that's what they're stuck with because that's what your client did. What else corroborates his statement? He tells you in his statement, I knew who it was because of the picture on her wall. And guess what Tara had, as Agent Roster told you, or Agent Baudry, I think he said, I went and got her picture off her wall. If he wasn't in that house, how did he know that she would have a picture of herself on her wall by herself? He doesn't say, I saw family pictures on the wall. I saw a picture of her on the wall. That's why you believe it. Physical evidence doesn't lie. And what he tells you matches the physical evidence. The trash, the house, blood on her comforter. You know, again, we can't tell you. I'm not trying to say whether it's menstrual blood, whether it's blood from this. Can't say. But there's blood there. He wants to say it's consistent with sex or a monthly cycle. Maybe it is. You heard every witness. We can't tell you. But it's also some evidence that a struggle occurred there. Inside that bedroom, there's evidence that you can believe circumstantially, and circumstantial evidence and direct evidence the judge will instruct you, you can give them the same weight. Direct evidence is like he hit her, he confessed to doing it. That's direct evidence. Circumstantial evidence is other things that corroborate that, and you give them equal weight. They're not different. You don't give them different weight, you can give them equal weight. In this video, talk about with his actions, with his motions, with his hands. He tells you what he did. You don't lie about that. He says, I picked her up and I carried her out of the house in a quilt. She was so small. And he does this motion.
It's like I said, I wasn't involved. I couldn't have involved here for
Just put her over your shoulder. You see her back in the quilt though, right?
yes, sir, I carried her. It's small. And I just put her in front.
She was so small. And I just carried her to the truck in the quilt and took her to the orchard. We know she was home that night because these are the clothes she wore to the pageant. Picture of her at the pageant. The coat she has there in her hand. And he tells you that he broke in her home because he's a drug addict, needing money for drugs. He also confesses to you in his own handwriting. And ladies and gentlemen, he doesn't say, I'm scared, I'm low dukes. Doesn't say, scared for my family. That's something he's told you 5 years later. Never told that any of that to the police. Brian Duke. Words are useless. But I am burdened with the guilt of murdering Miss Grinstead. That picture, he's burdened with her guilt of murdering her. His own handwriting, his own words. He doesn't say burning her body or both forcing me to burn her body. He says murdering her. I am burdened with the guilt of murdering Miss Grinstead. I don't feel like I deserve to be free to breathe. I can't begin to comprehend the pain I have caused to her family and loved ones. Changed his mind about all that, apparently, as they still sit. Months of misery, years of torment. I don't feel like I need to live with the pain I've caused. The things I have done are a double-edged sword with no handle. All that get near me are woefully injured. I can't take back the things I have done, but I hope today is the first step to being a good person. A title I don't deserve or merit. I am sorry for everything. The stupid, cowardly way I have hidden the truth. Still hiding it today. He hid it for 12 years, and he continues 5 years later, still hiding the truth. May God forgive me because I can't and won't. He confessed to burning her body. While we're talking about burning her body, I want to talk about a few things. Let's talk about motives. I couldn't stand before you and tell you that Bo Dukes is a good person. He ain't, in good South Georgia language. Is Bo Dukes a liar? Yes. In fact, in Wilcox County, Georgia, see that name at the bottom down there? It says Bradford L. Rigby District Attorney. That's me. He was charged with making a false statement. Count 1, that he did. Falsify and cover up that he confessed. Cover up that Ryan Duke had confessed to him that Ryan Alexander Duke killed Tara Grinstead, a material fact in her disappearance. That's all agents should do. He was also in Wilcox County charged with making a false statement, hindering apprehension of Ryan Duke, and concealing the death of another. 4 different counts that Bo Dukes was convicted of in Wilcox County and is in prison for, as they marched him in here in his prison clothes, paraded him before you as some big spectacle for the media. But that's what media lawyers do. Convicted in Wilcox County and is serving a sentence of 25 years. Did I hide him from you? I didn't hide him from you. I'm not going to put a convicted liar on the witness stand. You would look at me like I was crazy, putting up a man I convicted for lying. And lying about the fact that he covered up Ryan's confession. Hide anything from you? And they knew good well he was going to take the Fifth Amendment. He's got pending charges in Ben Hill County. He had his lawyer here with him. Of course he's going to take the Fifth Amendment. They want to talk about their client and his rights. He has rights too. Of course he is. That was all for you, for a show, for drama, for television. That's all it's about. Bo Dukes is not a good person. Never said he was. Never heard that come out of my mouth, Ms. Hart's mouth, or any other witness's mouth, because it's not the truth. He's not a good person. He's a liar. I've convicted him of lying. Charged him with lying. Convicted him of lying. He's got a bad reputation. I don't dispute that. But let's talk about it. Who's his best friend? Every time I see one, I see the other. They're always together. Ladies and gentlemen, they made you think this was about power and influence and Bo's family having power and influence. The man serving 25 years in prison. And Bo had so much power, he was living in a trailer with Ryan Duke. His family, Ryan even told you his mom had kicked him out. His family didn't want anything to do with it. He had such power and influence. They want to talk about power and influence. That, the state was influenced by Representative Newt Hudson from the grave, apparently. So influential, Bo Dukes got 25 years in prison. That's how influential. It still has pending charges. Not one email, not one text, not one phone call from anybody that they put into evidence to show power and influence in how this case was done. Because it doesn't exist. You hold them to that too. They're going to tell you they're going to prove something. Prove it. They can't. Didn't happen. Maybe fun to talk about and fun to think about conspiracies and how that didn't happen. Bo Dukes is not a good person, but who's his best friend? Who's always with him? Who lived with him before and after the murder? Who even went to ABAC and lived in the dorm with him? This defendant. Oh, I didn't know how to get away from him and get out of it. Oh, I'm going to go live with him in ABAC in the dorm. After he's ruined my life and made me Tara Grinstead. Scared of Bo. I'm scared of Bo. Come on now. And ladies and gentlemen, if Bo had done this, Bo doesn't need Ryan's help. It's Bo's truck, Bo's orchard. Ryan needed Bo's help. He didn't have a vehicle to carry her body. He had to get Bo's. He put her out on Bo's family's property. He needed Bo's help. Ladies and gentlemen, they put in a conviction for Bo Dukes for stealing from the military. And he did. He's convicted of it. I'm never going to tell you he's not a thief and not a good person and not a liar. He is. Convicted of it. Best friend, though, is Ryan Duke. What did Ryan tell you? Ryan didn't steal from the military. He stole from his own brother. Remember what he told you? I forged some checks on my brother. Don't you think if he just asked his brother, hey, can I have $50? He'd have given him $50? Of course his brother would. Stephen Dukes is a good person. But he stole from it. You want to talk about character? That's character. Bo steals, Ryan steals. I can tell you, they want to talk about character evidence. Everybody said Ryan was peaceable and Ryan's truthful. They put in some witnesses to say he had good character, but they knew him back in high school. Not really around this time, but fair enough. They put the evidence in. There's a man that would have had 11 character witnesses walk down here, they come up on the witness stand and raise their hand and say, this man is truthful and honest. He wouldn't do anything. He's a person of good character. We trusted him. We would trust him with our money. In fact, we do trust him with our money. And they would have all testified to his good character. But that same person is the one that betrayed with a kiss. In the garden. All of the disciples would have said, not Judas. As he was the thief. They didn't know that about his character. Right? They were even asking at the upper room, who would do this? Because sometimes people hide who they are. Just like he did. Bo was just open about his deviance. But his best friend just hides it better. You all know people like that. They go to church and they're one way, and they're out of church, they're something else. They just hide it a little better than others. Bo's just out front with who he is. Remember Garland Lott, young man that was their high school friend out at the orchard. They want to talk about Ryan getting up and crying about helping burn her body. But 2 to 3 weeks after it happened, what was Ryan doing about it? Laughing. The statement was, again, Mr. Lott told you, I can't remember who said it. It was one of them. They were both in the truck, and one of them said, we killed her and we burned her body. And they were both laughing about it. As he laughed in this courtroom. That's how much he respected women and respected Tara Grinstead. That's who he is. Says he's not a liar. He's a truthful person. Ladies and gentlemen, you heard him on the witness stand. We impeached him with his own lies out of his own mouth. You told Zach Gerard on a phone call, and you heard the phone call, and this is his respect for women. He's on a phone call that he knows is recorded saying, I had sex, I screwed Tara Grinstead, and I was screwing her from high school. Oh, but that's all a lie. Because that's about the media.
I just fucked up my life. I know destroy hers and her family's. But small things go different. You know, me not leaving the 8,000 million fucking possibilities got there. He tried to treat it however I could, drugs, alcohol. I mean, alcohol that killed me. Just that kind of idiotism, it's been passed throughout. I'll take it back, no matter how much I wielded it, wanted it, prayed for it.
I can kind of see it. It's coming off of you a little bit the more we're talking. I mean, you're upset, but you're not like you were when we first started.
I had all night with myself. I mean, I went through every lie I could have told. The only fucking voice I kept hearing was just tell the fucking truth. Be a man for once. I tried to be the person that people thought I could be.
The man he was scared of, he Facebook messages. Hey man, just wanted to say hey. After all these years. That's when the GBI comes and talks to him. But he's scared. But the one who's been living in his trailer, he goes and lives at A back with. And then we disproved that he was telling you the truth because Zane Deal came in here and Cliff Benson came in here and said, I've never been to a house where Bo and Ryan lived in Fitzgerald. Not the trailer and not the house. And Bo never said any of that to me. Who's lying to you? Who stands to lose the most? Didn't happen. And they said that, who testified, heaven forbid they got off script. I mean, we lost our pages for a few minutes and we just couldn't even continue the testimony because we got off script. Who's playing games with you? They want to attack the DNA and attack the fingerprints, but then, well, of course, the glove's planted. An innocent man just needs one defense. They don't need, it's not that, it's not his DNA, it's not his fingerprints, it's not this, it's not that, it's not. It's planted. Not his phone call. He didn't make that phone call. Don't want the phone call. He's going to admit he made the phone call. We're going to put up Dr. Talitsky to talk about the statement and how Jason Shadell used all these terrible techniques and everything else, and then they're going to put their client and say, I was just going in there to confess. Why? Smoke and mirrors, ladies and gentlemen. And apparently, since his personality assessment that you've probably all taken one like, apparently he's changed on the stand. Just smoke and mirrors. Not one expert from DNA or fingerprints that they call to say it wasn't his print or wasn't his DNA. Not one. They could have. Let's talk about the door lock. Let's talk about her shoes and yoga pants since they want to talk about those things. I'm not required to prove those or answer any questions about those, but let's talk about it because I'm not afraid of it. I'm not hiding anything from you. There was evidence that, yes, she would normally lock that top lock. What did Maria Hewlett, I can't remember her married name now, what did she tell you, though, her best friend? If she was expecting company, she wouldn't lock the top lock. And ladies and gentlemen, we all have habits, and you know what? There are times when I forget to lock my front door. And maybe if I'm not ready to go to bed yet, maybe if I'm still up and moving about in my house, I'm not going to lock my front door even though that's my habit. It just hasn't been done yet. There's not one person that's come in here to you and told you that she locked that night. Not one. Brian Duke burned her in her yoga pants. And did you see Maria? Oh, and Maria also told you, as you remember when Maria testified, she said, Tara and I have locked ourselves out of that house. Sometimes we just use a credit card to pop it. It was easy. What did Ryan tell you in his statement? It was easy. Pop it. The credit card. Oh, what was their response to that? Did you check and see if Ryan ever had a credit card? Who's playing games with you and smoking mirrors? Does it have to be his credit card? Can he just get his dad's or his brother's or stolen one from the houses he's broken into? Just games they play. Seek the truth. Be truth seekers, not doubt seekers. He confessed his DNA. We talked about that on the glove. 90%, 10% on the inside, 50-50 on the outside. We had that in 2000. We had his DNA in 2005, ladies and gentlemen. Just didn't have it matched to him at that point. But we had an unknown male contributor's DNA in 2005, and when we tested it in 2015, 17, 18, it's his. And the guilty knowledge we kept back on is not only did we have the unknown male's DNA, we had Tara's on it as well. Which shows you that Ryan Duke came in contact with Tara Grinstead. And it had to be before they burned the body. That's why that glove corroborates. And physical evidence doesn't lie to you. People will lie to you every day. Physical evidence does not. He confessed to making that phone call. Palm print on the glove. He confessed when he took them to the orchard. In fact, you'll remember in that video, the GBI tent is already set up of where they're digging at the first location, as Ty Crosby told you about it, and he even walks by it. He says, no, it's not over there, it's going to be on over here. If he was just going to agree with them where it was and what was done, what's he going to do? Just agree with where they're already at? No, that's it. But no, he shows him and Jason at one point says, well, we'll just follow you. And he's not cognizant because he's taken Vicodin, Percocet, marijuana, all of these drugs, and he's out there walking in briars and everything else in slide shoes. In fact, even has the presence of mind to know that his pants are falling down and wants to pick him up because he doesn't like saggy pants. But he's blitzed out of his mind on all these drugs. Doing that. That's what they want you to believe. And you had two agents, Agent Shadell and Agent Holland, tell you he exhibited no signs of impairment. And you saw him on video. Doesn't slur his speech or unresponsive to questions. Sometimes he says he doesn't know. But he doesn't make up a crazy story. It doesn't fit with the question asked. In fact, he corrects Agent Shadell according to the testimony of the GBI inspector yesterday corrected him 21 times. In that statement. They put Dr. Chalitsky up to say that he was blitzed out of his mind. And then he gets up there and tells you, after all that defense and theory, that, the statement, you can't believe it because he was on so many drugs. And Miss Merchant even told you in her closing that we don't even really know how many drugs he was on or what he was on or if he took a pain pill. We don't even know because he lies. He says on his statement, a pain pill this morning, and it's the afternoon when the interview goes. He says, a pain pill. He's already told you he's a drug addict, so his tolerance is going to be high. And he says, I'm fully cognitive. He confessed to you in his handwriting. He confessed to you with his actions of how showing you. You don't make that up if you didn't do it.
I mean, obviously, when you cremate a body, you know that you're the one responsible for this.
I killed her. I mean, it's my fault she's gone. I have no illusions about that.
I have no illusions about that. His words. His mouth. His confession. This is why he's guilty. Because and he also says in this statement, there's not a lot of blood at the house. If he thinks Bo Dukes killed her, and Bo Dukes didn't tell him how he killed her, because that's what he testified to, how's he going to know that there's not a lot of blood at the house? How do you know that? Unless you were there and you did it. Ladies and gentlemen, let me tell you one other thing. The judge is going to charge you on party to the crime, if someone directly or participates in it, that they're just as guilty as others. You may believe that Bo Dukes and Ryan went over there together and killed them together. You may believe that. And that's okay if you do. But it doesn't make his guilt any different. He's still as guilty, if not. And you may believe that Bo went in that house with him and they did it together. You may believe that. And that's okay. But it doesn't change that he's guilty too. The judge will charge you on parties to the crime. One knowing, directly committing, or participating in is just as guilty as the other. Ms. Grinstead, they wanted to argue that this case was about power and influence. This killer, this murderer, right here in this chair, this Ryan Duke that confessed to you, that night in her home, he had all the power. Tara was powerless. He had all the influence that night. He's had all the influence over her family from 2005 to 2022. He's had the power and the influence. He did everything he could to erase the very memory of Tara Grinstead and who she was, the teacher that she was, the career that she was pursuing, the children that she was affecting. He took her from her sister, he took her from his mom, his stepmom, and her father. And he even tells you in his statement, I kept her from being a mom and a grandmother and enjoying life. I took that from her. He had the power. And he had the power over her in her house that night. He has had that influence over her and influence over her family as they have been tortured. You heard the desperation in Miss Faye's voice in those answering machine messages, the desperation in Keith Dyke's voice. This is what he's done. This is why his guilt was overwhelming. This is his character. He just hid it better than both. They're both thieves. And they're both enemies. And they're both burning fire. In fact, they wanted to erase Miss Grinstead's memory so much that they reduced her to a bone. They burned her body, a full skeleton, down to about 20 fragments of bone. A little piece of vertebra, cranium, and took the smile from beauty pageants and reduced her to a few teeth. They wanted to erase the memory of Tara Grinstead and who she was and what she had done so much that they burned her to just little pieces. We couldn't save Tara Grinstead in her home that night. We didn't have any power to save her. We didn't have any influence to save her that night in her home. He had that. And he took it from her. He took her soul from her. He took her life from her. One of God's souls. He took it from her. As he struck her with his hand, he left her and came back and got her body and took it out to the orchard where he got his friend to burn it. Burn it to the crisp where DNA can't even be extracted from. But today, in this courtroom, justice has the power. The law has the influence. And you as the jury have power to honor Tara's memory. You have the power to seek the truth and to do the right thing. They ask you to seek doubt. I ask you to be a truth seeker. The truth is, just as he told you in his confession, he murdered Tara Grinstead as he burglarized her home. He struck her, removing her life. And then to cover it up, he got her body out and took her to the orchard where he burned it beyond recognition. Today, Ocilla, Georgia, has had an influx of media. An influx of media since this has begun. And today, Ocilla, in Irvin County, are truth seekers. And you can honor Tara's memory. You have the power and influence today to honor her memory, to honor Mr. Billy, to honor Miss Connie, to honor Anita, to honor her mother. They wanted to reduce her memory to trash in little pieces of bone. But you can tell the media all over the United States and all over the world, from Osceola, Irwinville, Lax, and Ray, and Mystic, that truth is what we do in Osceola. And you seek a verdict that speaks the truth today. There's only one verdict in this case that speaks the truth. And that verdict is for you to find this defendant in that chair guilty of being a murderer. That's the verdict that speaks the truth. And you let your verdict shine as bright as the fire they burned her with. And you find him guilty.
Thank you, Mr. Reed. We'll take a 5-minute indoor recess, come back for the charge, and then we'll break for lunch. If you'll please adjourn to the jury room, please. All right, we'll be in recess 5 minutes. All right, Mr. Norton, if there's any folks out there on the landing or anything that want to come in, tell them to come on in. If not, of course, that's fine. But, all right. And if there's anybody else who wants to, that's fine, but I just didn't want to. Yeah, you can let them in as they come up. Yeah, sure. I just didn't want 15 coming in here at one time. All right. Ask the jury to join us, please.
I'm sorry.
Well, hang on a sec.
I apologize. Can I ask something? I noticed in the jury charge you gave us again this morning that you did not include any requested language in the SLED case. Given the argument that was made by defense counsel related specifically to the inferences they can make from his invocations of the human right, I just once again ask the court to give us another charge.
Thank you. That's what we'll jury. All right. Ask the jury to join us, please. All right, please be seated. All right, ladies and gentlemen, as you know, you are considering the case of the state of Georgia versus Ryan Alexander Duke. Mr. Duke was indicted by the grand jury of this county on April the 12th, 2017, with the crimes charged of malice, murder, 2 counts of felony murder, aggravated assault, burglary, concealing the death of another. You'll have this indictment out with you during your deliberations. I'm going to go over the law, the charge with you at this time. Make notes if you want to, don't if you don't want to. I'm also going to send this charge out with you, so you'll have it back there. Some of these things can be a little confusing, so if you need it during your deliberations, I want you to have it. Now, Mr. Duke enters upon this case with the presumption of innocence in his favor, and he's entered his plea of not guilty. This indictment and that plea of not guilty is what forms the issue for you to decide. That's why you're here. I caution you again that the fact that the grand jury has indicted him is no evidence of guilt, and you should not consider the indictment as evidence or draw any implication of guilt simply from the fact that he's been indicted. Neither is his plea of not guilty to be considered as evidence. His innocence, his presumption of innocence, ladies and gentlemen, that he enters upon this trial with is obviously in his favor, and that presumption remains with him until it is overcome by the state with evidence sufficient to convince you beyond a reasonable doubt of his guilt on the crimes charged. No person, ladies and gentlemen, in our country shall be convicted of any crime unless and until each element of the crimes charged are proven beyond a reasonable doubt. And the burden of proof in that regard lies with the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. There's no burden whatsoever on a defendant to prove innocence, and the burden never shifts to a defendant to introduce evidence or prove innocence. If a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, as I'm sure you might imagine, the state is not required to prove the guilt of an accused beyond all doubt or to some mathematical certainty. A reasonable doubt means just like it sounds. It is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. That's the first thing they teach you in law school. is that the point of all legal investigation is the discovery of the truth. That's what a trial is. A reasonable doubt, ladies and gentlemen, is a doubt that is based upon your common sense and reason. It does not mean some vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from your consideration of the evidence presented, a lack of evidence, conflict in the evidence, or any combination thereof. If after you give consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, that is a doubt of the law, and you should acquit Mr. Duke. But if that doubt does not exist in your mind as to his guilt, then you would be authorized to convict him. If the state, however, fails to prove Mr. Duke's guilt beyond a reasonable doubt, it is your duty to acquit him. Now, as I told you when we started, it's my job to determine the law applicable to this case and charge you or instruct you on it. And you were bound by these instructions. It's your responsibility, ladies and gentlemen, to determine the facts of the case. And then you apply this law that I give you to the facts as you find them to be. Mr. Duke, ladies and gentlemen, is charged with certain crimes against the laws of our state. Now, a crime is a violation of a statute of this state in which two things are operating: an act and an intention. Okay? Intent is an essential element of any crime that must be proven by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you believe it exists from the proven facts that have been presented to you. It may be inferred by you from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is simply the natural and necessary consequence of the act. Whether you draw such an inference is a matter solely and totally within your discretion. Now, criminal intent does not mean an intent to violate a specific law or a specific statute. It simply means the intent to commit the act that is prohibited by law or statute. You are not to presume that Mr. Duke acted with any criminal intent, but you may find that intention or its absence upon your consideration of words, conduct, demeanor, motive, or all other circumstances connected with these acts for which Mr. Duke is being prosecuted. You've heard a lot of talk about evidence. The oath I gave y'all last Monday morning that you took in that box requires you to decide this case on the evidence. Evidence is the means, ladies and gentlemen, by which any fact that is put in issue is either established or disproved. It includes all the witnesses' testimony, all the witnesses that came in here and were sworn, testified before you, and it includes the exhibits that were tendered and admitted into the evidence in the case. Again, it does not include the indictment. It does not include Mr. Duke's plea of not guilty. It does not include the opening statements, the closing remarks you just heard, nor the questions of the attorneys. Now, we have two forms of evidence. We have what's called direct evidence, and then we have what's known as circumstantial evidence. Direct evidence is the testimony of any person who asserts that he or she has actual knowledge of a fact, such as an eyewitness or something they personally observed. Circumstantial evidence is facts and circumstances that tend to prove or disprove other facts by inference. One of the best examples I've ever heard, ladies and gentlemen, is if you're at home late this afternoon, sitting on your porch, and some clouds blow up and the wind starts blowing and it starts raining and you're sitting there watching it, well, then you can go to court the next day and give direct evidence that it rained at your house this afternoon at 5 o'clock. You saw it. But if you're out at your house and the wind starts blowing, the clouds blow up, and you go back inside and take a nap, but when you get up, you come back on the porch and the grass is wet and there's puddles everywhere, that's circumstantial evidence that it rained at your house at that time. You didn't see it rain, but you saw other facts and circumstances which could tend to prove that. There's no legal difference, ladies and gentlemen, in the weight that you should give either to direct or circumstantial evidence, and in considering the evidence that's been presented to you in this trial, you should use your common sense and reasoning to make deductions and reach your conclusions. Don't be overly concerned about whether the evidence is direct or circumstantial, but you would only be authorized to convict Mr. Duke in this case only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves his guilt beyond a reasonable doubt. Now, as to credibility of the witnesses, ladies and gentlemen, that's solely up to you. You must determine the credibility or the believability of the witnesses, and in deciding this, the law authorizes you to consider several factors, including all the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity for knowing the facts they came in here and testified about, the nature of the facts about which they testified, and the probability or improbability of their testimony, their interest or lack of interest in the outcome in this case, and their personal credibility as it was presented to you from your observations. Now, in determining witness credibility, ladies and gentlemen, you may consider evidence offered to attack or challenge the credibility or believability of a witness. This would include any character evidence for untruthfulness shown by the opinion of others through reputation evidence, specific instances of conduct of the witnesses brought out on cross-examination of that or of another witness that may relate to the witness's character for untruthfulness. Further, you may consider any evidence of bias towards a party, as it may have been shown by any bad acts or specific instances of conduct of the witness that related to the witness's bias towards one side or the other of this case. You may also consider any felony convictions or other convictions involving dishonesty, that being proof that a witness has been convicted of the offense of making false statements, hindering apprehension or punishment of a criminal, concealing the death of another, and conspiracy. Further, ladies and gentlemen, sometimes a witness credibility is attacked by one side or the other, and this is called impeachment. To impeach a witness is to show that the witness is unworthy of belief, and a witness may be impeached by disproving the facts to which the witness testified. Another assessment you may make, ladies and gentlemen, of a witness's credibility may be affected by comparing the testimony that the witness gave in this chair to statements the witness made before trial. It's for you to decide whether there is some reasonable explanation for any inconsistency in a witness's pretrial statements when compared to what they said in this courtroom. Now, further, as to credibility, ladies and gentlemen, a witness who has had their credibility attacked by one side or the other or challenged, as I have described to you, you may also consider any evidence offered to support that witness's credibility, which would include, as opposed to evidence of character for untruthfulness, evidence of character for truthfulness. This may be shown likewise by the opinion of other witnesses, may be shown by reputation evidence, or specific instances of conduct of the witness in question brought out on cross-examination of that or another witness that may relate to that witness's character for truthfulness. Also, any evidence you may have observed about lack of bias the witness may have had towards one side or the other. This likewise could be shown by truthful conduct or other specific instances of conduct of the witness that relates to their lack of bias toward a party. Just like with all other instances and examples of credibility, ladies and gentlemen, in your analysis, you should apply your common sense and reason to decide what testimony you believe and what testimony you don't believe. We've had a number of expert witnesses, ladies and gentlemen. I tried to call those to your attention as they were presented. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common or known to the average citizen, and the law permits expert witnesses to give opinions based on that training and experience. You are not required, as I've told you throughout the trial, to accept the testimony of any witness, expert or otherwise. Testimony of an expert, just like that with all witnesses, is to be given only the weight and credibility that you think it is properly entitled to receive. Now, as to the defendant's pretrial statement, ladies and gentlemen, a statement that the defendant allegedly made while in custody has, of course, been offered for your consideration. Before you may consider that as evidence for any purpose, you must determine whether the statement was voluntary and whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestion or promises of leniency or reward. A statement that is induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by anybody else. In determining voluntariness, you may also consider to what extent the defendant was informed of his or her rights, as I will discuss with you in a moment. You may also consider, ladies and gentlemen, the legality, the duration, and the conditions of any detention as factors relevant to the question of whether or not the statement was freely and voluntarily made. However, under the law, in order for a statement to be excluded because of illegal detention, it must be shown that the statement was in fact induced by that illegal detention. The burden of proof, like every other element, ladies and gentlemen, rests upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find Mr. Duke's statement was voluntary, you may not consider it for any purpose. Now, if you find that the statement the defendant made while in custody and as a result of his questioning was voluntary, you must also determine whether he was advised of his constitutional rights and whether he clearly understood and gave up those rights. The constitutional rights law enforcement must explain, and the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. The defendant has a right to remain silent. The defendant, if he chooses to remain silent, or if he chooses not to remain silent, anything he says or writes can be used against him as evidence in court. That he has a right to consult with an attorney before any questioning, and to have the lawyer present with him at all times during questioning, and if he does not have resources to hire an attorney, that a lawyer will be provided for him to represent him before any questioning and to be present with him during any questioning. Likewise, on this issue, the burden is with the state to establish that all of these warnings that I just gave you were given, that they were understood, and knowingly given up by Mr. Duke. Now, if you find that the defendant's statement was voluntary, as I've described to you, and that all the warnings of his constitutional rights were given, and that he understood the meaning of what was said and knowingly gave up those rights, then you may consider that statement as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, that you will give to any or all parts of the evidence. If you fail to find that Mr. Duke was properly informed of these rights and that he understood and gave up those rights, you must disregard his pretrial statement entirely and give it no consideration in reaching your verdict. As to corroboration of a defendant's out-of-court statement, a defendant's out-of-court statement that is not supported by other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. However, proof by other evidence beyond a reasonable doubt that the crime alleged has been committed may constitute supporting evidence of a defendant's statement should you so find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not the evidence sufficiently supports the defendant's statement so as to justify a conviction. If you find there was a statement made by the defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of the guilt of the defendant beyond a reasonable doubt. You should consider, ladies and gentlemen, with great care and caution the evidence of any out-of-court statement allegedly made by Mr. Duke, offered by the state. You may believe such a statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of that evidence. As to parties to a crime in Georgia, ladies and gentlemen, every party to a crime may be charged and convicted of the commission of the crime. A person is a party to a crime only if that person directly commits the crime or intentionally helps in the commission of the crime or intentionally advises, encourages, hires, counsels, or procures another to commit the crime, or intentionally causes another person to commit the crime under such circumstances that the other person is not guilty of any crime, either in fact or because of any legal incapacity. Any party to a crime, ladies and gentlemen, who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or who has been acquitted. Now, knowledge on the part of a defendant, ladies and gentlemen, that the crimes charged in an indictment and against them were being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such a crime must be proven by the state beyond a reasonable doubt. If you find from the evidence in this case that Mr. Duke had knowledge that crime was being committed, or that he did not knowingly and intentionally commit or participate or help in the commission of the offense, then it is your duty to acquit him. If he had no knowledge the crime was being committed and did not knowingly and intentionally commit, participate, or help in the participation of the crime or commission of the crime, it's your duty to acquit him. On the other hand, if you find beyond a reasonable doubt that he had knowledge that the crimes charged were being committed and that he knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict him. It's for you, ladies and gentlemen, as to the identification of Mr. Duke, it is for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances sufficiently identify Mr. Duke beyond a reasonable doubt as the perpetrator of the alleged crimes, or that he was a party to it. It is not necessary that the defendant show that another person committed the alleged offenses. Now, if you do not believe that Mr. Duke has been sufficiently identified as the person who committed the alleged crimes or was a party to it, or if you have any reasonable doubt about that, then it is your duty to acquit Mr. Duke in this case. Once again, the burden of proof rests with the state to prove beyond a reasonable doubt the identity of this defendant, Mr. Duke, as the person who committed the crimes alleged in this indictment. Now, as to the fingerprints and palm prints, that's all the same thing. Certain evidence of fingerprint and palm print comparison has been admitted by the court for your possible consideration. Identification by fingerprint and palm print comparison is opinion evidence and is dependent upon the credibility and accuracy of the expert witnesses called for that purpose, as well as the following factors: the validity of the theory of identification of fingerprint comparison, the credibility of the witness who performs other necessary functions in making the comparison, such as inked fingerprint impressions and latent lips, and the accuracy of procedures in identifying, preserving, recording, and maintaining the integrity of the physical evidence. All of these are questions for your consideration. Fingerprint evidence, ladies and gentlemen, is also governed by the rules of circumstantial evidence. Now, if you believe the fingerprints or palm prints corresponding to those of Mr. Duke were found and identified, their evidentiary value, if any, would be diminished to the extent that they could reasonably have been left on the article alleged, that being the glove, at a time or under circumstances that would be consistent with his innocence. A verdict of guilty may not rest upon fingerprint identification alone unless you are satisfied beyond a reasonable doubt that the fingerprint and palm prints left by Mr. Duke were in fact found, and that they could only been impressed by Mr. Duke on the article alleged at the time of the commission of the crime, and that such identification under all of the facts and circumstances of this case is sufficient to satisfy your mind of Mr. Duke's guilt to the exclusion of any other reasonable theory and beyond a reasonable doubt. DNA evidence, ladies and gentlemen, has been submitted for your consideration. Identification by DNA comparison is likewise considered opinion evidence and governed by the laws concerning opinion testimony that I've given you as to expert witnesses. And as opinion testimony, ladies and gentlemen, evidence relating to DNA comparison is dependent upon many factors. Among those are the credibility and accuracy of the witnesses who were involved in the process of obtaining, identifying, preserving, recording, and maintaining that physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these are issues and matters for you to consider and determine. It's for you to determine the weight, if any, that you will give the evidence related to the DNA comparison in reaching your decisions in this case. You've heard evidence, ladies and gentlemen, of good character on behalf of Mr. Duke. You have heard evidence for particular traits in that regard, more specifically peacefulness and truthfulness, in an effort to show that Mr. Duke likely acted in keeping with those character traits at pertinent times or with reference to the issues in this case. This evidence is offered to you in the form of opinion of other witnesses and by evidence of reputation. You should consider any such evidence in this regard along with all the other evidence in deciding whether or not you have any reasonable doubt as to the guilt of Mr. Duke in this case. Now, facts and circumstances, ladies and gentlemen, that merely place upon a defendant a grave suspicion of a crime charged, or that merely raise a speculation or conjecture of a defendant's guilt are not sufficient to authorize a conviction. Further, a jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the crime of its perpetration guilty of consent in and concurrence in the commission of the crime unless the evidence shows you beyond a reasonable doubt that such person committed the crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. Further, ladies and gentlemen, the jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or otherwise participated in the criminal endeavor. As to statute of limitations, ladies and gentlemen, in our state, the law of our state sets a time upon which the state, a time limit, upon which the state has to start the prosecution of most criminal offenses. In counts 4, 5, and 6, the aggravated assault, burglary, and concealing the death of another, Mr. Duke is on trial under those counts, and under Georgia law, the prosecution for these offenses must commence within 4 years after the offense has been committed. Further, if you find from the evidence that the indictment or accusation in this case was not filed within 4 years after those offenses were committed, it is your duty to acquit Mr. Duke on those counts of the indictment. And as I mentioned, I'm talking about 4, 5, and 6. Now, in calculating this time period, ladies and gentlemen, you should exclude from your calculation any period of time during which the evidence shows the crime itself was unknown. When the statute of limitations defense is raised, ladies and gentlemen, the burden is on the state to prove that the offenses occurred within the statute of limitations or within an exception thereto beyond a reasonable doubt. Now, as to the offenses charged, ladies and gentlemen, in count 1, malice murder. In Georgia, a person commits the offense of murder when he unlawfully and with malice aforethought, either express or implied, causes the death of another human being. To be murder, the killing must have been done with malice. Express malice is that deliberate intention to unlawfully take the life of another human being which is manifested by external circumstances capable of proof. Malice may be implied where no where no considerable provocation appears and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation in order to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent may have existed. No specific length of time is required for malice to arrive in a defendant's mind. Malice may be formed in a moment and instantly a fatal wound be inflicted. If malice was in the defendant's mind at the time of the act of the killing and moved the defendant to do it, that is enough for the killing to be murder. Further, ladies and gentlemen, the state does not have to prove motive to prove murder. Any evidence of motive that has been admitted for your use in determining the defendant's state of mind at the time of the killing. Counts 2 and 3, ladies and gentlemen, are the felony murder charges. In Georgia, for felony murder, the state must prove that the defendant caused the death of another person by committing felony. Aggravated assault and burglary are felonies, and I will go over those with you in just a moment. Now, you may find Mr. Duke guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault or burglary or both, regardless of whether he intended the death to occur. But there must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after a felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. As to aggravated assault, ladies and gentlemen, which is count 4. For aggravated assault in Georgia, the state must prove that the defendant assaulted another person with an offensive weapon. An offensive weapon, ladies and gentlemen, can be any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. In deciding whether a hand is an offensive weapon, you may consider the following factors: the nature and extent of the injury inflicted, the character or capability of the weapon, the manner in which it was used, any display of it to you, and any other circumstance of the case. Count 5, the burglary charge. In Georgia, a person commits the offense of burglary when without authority and with the intent to commit a theft therein, he enters or remains in the dwelling house of another. And finally, count 6, concealing the death of another. In Georgia, a person who, by concealing the death of any other person, hinders a discovery of whether or not such person was unlawfully killed, is guilty of the felony of concealing the death of another. You've heard in the arguments about venue. Our Constitution in this state requires that any criminal actions be tried in the county where they allegedly occurred. Venue, that is, that the crime was committed in Irwin County, Georgia, is a jurisdictional fact which must be proven by the state beyond a reasonable doubt, just as any other elements of the offenses charged, and this may be done by direct or circumstantial evidence or both. Now, as to the murder charges, ladies and gentlemen, murder shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, venue is proper and may be proved in the county in which the death occurred. If a dead body is discovered in this state and it cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. Now, as to the form of your verdict, ladies and gentlemen, you'll see when you get in the jury room, there's a place on this indictment for you to fill out a verdict form. I don't want you to use that one. I prepared a separate verdict form that I've been over with everybody. This will go out with you. This will be where you record your verdict. And in that regard, you should reach it as follows. First, as to count 1, the malice murder charge, if after you consider all the testimony and circumstances and evidence presented to you, together with this charge, if you should find and believe beyond a reasonable doubt that Mr. Duke did in Irwin County, Georgia, on or about October 23rd, 2005, commit the offense of malice murder, as it is alleged in count 1 of this indictment, you would be authorized to find Mr. Duke guilty of this charge of the indictment. And in that event, the form of your verdict would be, we the jury find the defendant guilty of count 1 of the indictment, and so record your verdict. But if you do not believe that Mr. Duke is guilty of malice murder as it's alleged in this indictment in count 1, or if you have any reasonable doubt in your mind as to his guilt on this charge, it is your duty to acquit him of malice murder, and in that event, the form of your verdict would be, we the jury find the defendant not guilty of count 1 of the indictment, and so record your verdict on this verdict form. That analysis, ladies and gentlemen, you should use on each count, and consider each count separate and distinct. Now, you are only, ladies and gentlemen, to concern yourself with the guilt or innocence of Mr. Duke in this case. You are not to be concerned about any punishment. One of the first things you ought to do in the jury room is select one of your number to serve as a foreperson. The foreperson will preside over your deliberations and is called upon to sign this verdict, to which all 12 of you must freely and voluntarily agree. I hope that, ladies and gentlemen, you will open your deliberations and conduct your deliberations with an open mind. You should consult with each other, and you should consider each other's views. Each of you, however, has to decide this case for yourself. but you should only do that after a discussion and consideration of this case with your fellow jurors. Don't ever hesitate to change some opinion you may have if you become convinced that you're wrong. But you should never surrender any honest opinion that you have just to be congenial or to reach a verdict solely because of the opinions of the other jurors. Whatever your verdict is, ladies and gentlemen, it must be unanimous. That is, it must be agreed upon by all 12 of you. It must be in writing, as I've said, signed by one of you as foreperson, dated, returned in open court, and published or read out. This form of charge, ladies and gentlemen, I've prepared here for these instructions. They're intended to help you, of course, with this case, and if you need to refer to it, I put headings in this charge to help you find any specific topic you may be looking at or looking for. You should consider these instructions in their entirety and as they relate to other portions of this charge when applying the law that I give you in these instructions to the facts as you find them to be from the evidence that's been submitted to you. I hope that nothing that I have done or said, or if I made a face or anything like that, leads you to believe that I have any opinion upon the facts of this case, the credibility of any witness, upon the evidence, or about the guilt or innocence of this defendant. That's not my role. I've told you my role is to make sure we have a fair trial and that you are properly instructed on the law that you're to apply. If you have observed something that I've done that makes you think I have an opinion about it, please disregard it, because I don't. Everybody's got their role in this trial, and mine is not in regard to the guilt or innocence in this case. My only deal is for you as honest and conscientious and impartial jurors to consider this case as I have instructed you, and that you return a verdict that speaks the truth as you find the truth to be in this case. Now, what we'll do at this time, ladies and gentlemen, lunch hour's here. That took a little longer than I thought, but I'll have the lunch brought up here and delivered to you, okay? At this time, the first 12 will retire into this jury room here. The alternates, I'm going to ask y'all to have a seat out there in the grand jury room. Since we have the first 12, or we've made one replacement, we have 5 alternates left. Y'all will not, as alternates, deliberate with the jury at this time. It happens all the time, though. Something may happen to one of the 12, and if we don't have alternates, we have to start over. So a few years ago over here in Irwin County, I had a jury deliberating, and one of them's spouse got in a wreck and the other one got sick, so we had to have 2 alternates. So please be patient with us. As an alternate, your presence is very important, but you will not deliberate with the first 12. All right. The following now, make sure you remember your number. And I know y'all just sort of set where you wanted to or in the trial of this case. The first 12, juror 18, juror 48, 56, 62, 64, 71, 75, 78, 79, 83, 85, 86, and our first alternate, 94. Juror 71 was excused, okay? Those 12, please step into the back, retire. Don't begin your deliberations, ladies and gentlemen, until you get this indictment, the charge, and the evidence that's been admitted. Thank y'all. Have a seat up there in the green. prior objections as to the content of the charge. Is there any objection to the delivery of the charge to the jury by the state?
None from the state, Judge.
By the defense?
No, Judge, you just renew our objection to number 1.
Timely made, overruled, and preserved for the record. Thank you. Y'all got a job to do now with this evidence to send out. Have y'all had an opportunity to look at it? We don't want to send out any summaries, right? Nothing violates the continuing witness rule. Here are these charges of Mr. Dukes. Of course, yeah. All right, let me ask you, Ms. Hart, Ms. Merchant, y'all have any objection to them deliberating while they're eating?
No.
Yeah, I
None.
wouldn't think so.
None, Judge.
Yeah. All right.
Yeah, I've got a lot of them up here. I'm trying to put them in order.
Together, and just repeat the statement.
Is there anything that y'all, of your exhibits, that you believe should not go out, or you think
We
it?
have 4, and I think they all go out.
All right.
I think all of those were pictures, Judge, so I would agree with that.
And the
Well, now
conviction,
4 is the,
certified conviction.
yeah, and federal court conviction.
I would have to look at that, Judge. Normally, we have not sent convictions out or certified copies out. If it does go out, it cannot have certain portions of it in it.
All right.
It's not a big deal if it goes out or not to us, as long as none of the other states go out.
I
No,
think-
we agree, it would be as to both
All right, we'll
Mr.
just,
Dukes and that one.
we'll just leave out both of those certified convictions. Can y'all think of anything off the top of your head in the state stack of evidence that should not go out other than the,
Well, I can think.
Nothing comes to mind immediately, Judge, but we would like a chance to just look at it once it's organized.
sure.
His statement would not go out, Judge, the one that he wrote that during,
Bonnie,
interview
what's
with law
that,
enforcement.
what's that exhibit
Um,
number?
I'm sorry, they took my exhibit numbers away because they're trying to get some other stuff in order.
Statement, letters, summaries, I think that's it.
His statement, Judge, defendant's statement,
Judge, that's,
Whatever it is, yeah.
Oh, I think there was a summary prepared by law enforcement on the phones. I think the summary doesn't go out, the phone records go out. By
Yeah, that
no
was,
objection to that.
That was Brody's or
Audrey.
Bill Baudry.
Baudry's, yeah. Yeah, I agree with that.
Obviously, the CDs and would not go out. The written statement is number 181, Judge. Apologize, these weren't already in order. They were using some for closings.
All right, Mr. Merchant, these are your exhibits 1 through 6 from our pre-trial hearing we had on Mr. Posey's. Where's our clerk?
Probably gonna get lunch.
Yeah. Ms. Ross, yeah, that's 1 through 6.
Just make sure they don't. Judge, well, I think I'll just, if it's okay, I'll get them in order and then I'll just tell the court what I think would not go out. That'd probably be quicker. Where does that start? 48?
What about the bones in the teeth? Is there any hazard, biohazard for any of that?
There's not, Judge.
I didn't see y'all using gloves, did you?
No, sir. They've been cleaned.
Plus, no DNA still exists on them, obviously, so nothing else does either. Are there any more pictures over
Ms.
there?
Pope, if y'all want to go ahead and deliver the lunch to the jurors, then that's fine. Thank you. It is in there.
Switch it. Those
Once you
are
deliver this stuff to them, you just tell them when they reach a verdict or have any questions, just knock on the door. Okay?
I think I'm getting close, Judge. There's a big gap right there. So the answer is yes, but it's a big gap right this second. Those phone records have gotten separated, so hold on to those for now, please. Okay, just a second. You said 81 and 82? I'll just put them on top right here.
We use this clerk in here, are we free to retire?
I'm gonna handle that.
I think she can handle it. Thank you.
I'm pretty sure she can.
Since we will be discussing evidence, are they waiving the defendant's presence, Judge? I take that as a yes. Thank you, Judge.
Can I tell?
I think it'll be too many
Stay out.
cooks in the
That's why
kitchen,
I was like,
honestly.
what?
No.
Yeah, I'll stay away.
But I appreciate the offer. Thank you. Not a clue. But you know who would know? It's Miss Connie. You can text Rebecca because I'm camera showing. Okay, you know what?
Forgot.
Oh well. Bet when I see him. Okay. What did the ones you have start with? I'm sorry?
Start at 81, 18, 212.
Okay, that stack's a lot.
got a note from the jury that I'll share with you. Let me put this in the record. It says, can you please clarify this question for the jury regarding number 22, venue, in jury instructions? Please define the term venue as proper and explain how it applies to to count 6, concealing death of another. If you'll exhibit that to the attorneys, please. I don't know if you have your copy of the charge there with you. I don't know how to, draft it any better. My suggestion would be to respond to the jury on this piece of paper that as used in this charge, the term proper just means appropriate or correct or, I want to help them. I don't know if, I guess it's clear to me, but I don't, please define the term venue as proper and explain how it applies to count 6. I don't know how it applies to count, how to explain them. That's a matter of evidence, how it applies to count 6 seems to me. But as far as what's italicized, venue is proper, please explain that term, venue is proper. So anyway, what's the state think?
Your Honor, since their question was specifically on point as to that count, we would ask the court to just recharge the first paragraph of number 22. I know they have it back there, but that's what we would ask.
That's exactly what I was gonna suggest.
Bring them back out and read the charge to them again?
No, I think you can just write it back. That so I think their question is the second paragraph looks like it only applies to the murder charge, and so and so I think
Well, it does.
Right, and so I think if you direct them to reread the first paragraph as to count 6, does that make sense?
Yes, it does make sense. I'm just rereading it myself right now. I mean, I could just tell them the second paragraph of number 22 only applies to the murder charge, right? And I mean, that's what it says, as to the murder charges. Maybe I should put as to only the murder charge.
I think you could instruct them that as to count 6.
The second paragraph of 22 doesn't apply.
Yes.
Does that suit you, Ms. Holmes?
Yes, Your Honor. We would ask, obviously, because I also don't want to confuse them, we would ask that the court, even though they're only asking about 6, that we direct that. I think I'm asking for the inverse. I would ask the court to say that the second paragraph of 22 only applies to the murder charges.
Well, I thought that's what I said, but I guess it didn't. Yeah. The second paragraph of 22 only applies to the murder charge.
That's what we're asking the court to charge is, or to write.
I thought that's what we were talking about. That's what you.
Yes, Judge. Thank you.
If you'll show that to both sides, please. All right, does that suit y'all? Okay, we'll be in recess. Yeah, please return that to the jury. We'll be in recess till we hear from them.